Imagine moving your entire life to the UK, changing careers, buying a home, paying thousands of pounds in visa fees, all based on a clear legal promise. Work hard for 5 years and you can apply for permanent settlement. Now, imagine the government turns around halfway through your journey and tells you, actually, it's going to take you 10, 15, or 20 years instead. That's exactly what the government's proposed earned settlement plan threatens to do. A major constitutional roadblock hit the Home Office. The House of Lords just dropped a massive report challenging the legality and the fairness of this entire plan. In this video, I break down exactly what the House of Lords gets right, where the major legal battle lines are being drawn, and what you need to do right now to protect your status. Let's get into it. If you watched our previous video on earned settlement plan, you know the government wants to create an economical stratified system. If you earn under roughly 50,000, your baseline to indefinite leave to remain could jump to 10 years. For some workers, it's 15. For refugees, it could be 20 years. But the House of Lords flatly refused to support this timeline expansion. Why? Because trapping families in prolonged permanent status of temporary status does not help them integrate. It stops them from buying homes, planning their children's education, and settling into their communities. Now, here is a piece of proposal that has caused absolute outrage on the legal communities. Retrospective application. The Home Office wants to see these new rules apply to people already living and working in the UK. The House of Lords did not hold back here. They explicitly call this proposal manifestly unfair and want that they may be completely unlawful. You cannot invite global talent, healthcare workers, and essential professionals to your country under one set of rules, take their money, and then change the rules of the game halfway through. It destroys the UK international reputation of fairness and the rule of law. What I love about this report is that the House of Lords also looked at everyday bureaucratic hoops migrants have to jump through. They called for a complete overhaul of the Life in the UK test, pointing out it is outdated and measures routine memorizations of trivial rather than actual civil integration. They also called for a more welcoming citizenship ceremony and a fairer scrutiny over how the government handles deprivation of citizenship. Essentially, the parliament is saying integration is a two-way street. If you want migrants to integrate, the government has an obligation to provide the condition for them to work and learn English rather than just treating immigration policy like a political tool for short-term headlines. So, what is the key takeaway for you if you are on a visa pathway right now? The proposals are not yet final. The government is going to face political, practical, and legal battles in Parliament this autumn. The House of Lords has just landed migrants, employers, and immigration lawyers a massive shield to fight back against moving this goalpost. But my strongest advice as a legal profession and as an immigration solicitor, do not wait for the battle to finish. If you already meet the criteria for ILR or British citizenship under the 5-year rules, file your application immediately to secure your status before autumn legislation shakes things up. If you need a comprehensive audit of your visa pathways to make sure you are safe, contact our legal team at Cross Border Legal Solicitors or click on the link on the description to fill out a quick inquiry form. Like this video, subscribe for a weekly update. I'll see you on the next briefing.